Okay, I've got a lot to cover in this presentation for your review, and there's a lot of text. So you want to make sure that you've got some time and that you're taking notes and that you're able to refer to the textbook reader at the same time. By this point, I hope what you're seeing is that within the criminal justice and legal systems, there is already an unequal social relations system, right? So in other words, the system is promoting unequal social relations. So that's a contradiction that cannot be resolved simply by saying I have a right to something. And this is because there's implicit bias in law enforcement. So just because you have the right to the Fourth Amendment does not mean that the police are going to respect that right or that you won't be in danger if you try to enforce your amendment rights. Same thing with prosecution, right? Just because you have a right to counsel, or you have a right to a fair trial, or you have a right to confront your accusers and see the evidence, that doesn't mean that's going to happen, right? Again, because there's implicit bias in the prosecution. So some people have a better chance of getting those rights than other people within this unequal system. And then it's very obvious when you start looking at the data that there's an extreme bias in sentencing. And so Black and Latinx communities, men in particular, especially young men, and poor and working class men are often sentenced far more harshly than people in different identities. You'll also see this play out in the criminal justice system in non-heterosexual normative identities and other gender-based identities. I think that's pretty well discussed in the media, so you're probably aware of how that bias works out. But it also works out in the criminal justice and legal systems, not just people's opinions and what they think. It actually happens in real life in concrete situations, and there's plenty of research that you can do on that. Just look at the homelessness problem, and you'll see, especially if you look at transgendered and non-normative sexual identities, you'll see a huge amount of discrimination in housing policy and who's able to get a remedy to discrimination in housing and who's not. So this very likely, in my experience, has challenged your non-research based ideas that there are good and bad people. And so now we're trying to look at systems, and this is what we've really been trying to get you to do for the last 3 weeks. And now, we're getting into kind of the heart of it, and so you're going to do that by looking at the issue of racial discrimination. Now, you want to think about this within this kind of, there's also unequal social relations within the field of criminal justice and constitutional law. And so the ideas have not caught up with this reality, right? They've been kind of also discriminatory and biased. And so there are, however, a fair number of legal scholars and criminal justice scholars that have been starting to put in new narratives and give more research that's based on people's actual lived experience that are not just including white property-owning men. And especially not ideals, but actually what happens in real life. And so we call this the polyvocality of legality. In other words, multiple ways of thinking and acting within legal institutions. And this involves a variety of legal consciousness, which means different ways that people are thinking about this or not thinking about it in a lot of cases. And also the ways, what we call multiple schemas or schemes, right? Ways of approaching and strategizing and using specific tactics of how to think about how this whole situation is constituted, meaning created by society, and what it allows individuals to do as far as latitude, going kind of horizontally or back and forth in interpreting these events, which we call social phenomena. At the same time, you're still going to be using those concepts of legality, both those that you're borrowing from the larger popular culture, those that are used in formal legal and criminal justice settings, and those that you use in your family in your own kind of situation. So this tells us that different groups of people, which we call constituencies, are speaking about law quite differently. And this matters because this principle of democracy means that we're all supposed to kind of come to the same ideals, but this is not the case. And so this definitely undermines the concept of representation and ideals of participatory politics, which is often called pluralism, the idea that everybody's competing for political power and everybody's equal, and so whoever happens to win in any particular election, well, that was fair and equal, which is not accurate, right? The groups that have more power, in most cases white men, dominate the political process as well as the lawmaking process, and so they have bias against other groups. which I think is very obvious in just the political rhetoric that you're seeing largely among and with white men in the political structure. So we want to think about then how to teach constitutional law, because that's going to be different if I'm talking to a group of upper class white men at Harvard than it is if I'm talking to a group of working class students at Kingsborough Community College or some other place. So judges engage in close reading of legal text. We call this exegesis, meaning this is what informs their interpretation process. It's very similar to what happens with religious scholars or rabbis, priests, and imams, that they have a certain way of looking at the text that's built on their education, their experience, and some of their ideological or their normative, what we call the way they think the world should be, their points of view. And so that's going to filter how they see the document. Then they're going to create what's called a proposition or a statement. This is what you typically refer to as rules. This is some kind of thing that is said that then has some kind of consequence. They're going to base those on those experiences, and that's what we call exegesis. So on a purely textual level of analysis, which I've read recently Justice Barrett is trying to do in the court, you should be able to analyze different interpretations of how that works out in practice. And so one case is the case Biden versus Nebraska, where you can actually look through the different opinions by the judges and just look at the words, right? Just look at the text that they're using, and you'll see that they're interpreting things very differently based on their normative point of view, based on what they think the world should be. So in some ways, this then basically allows, you can look at it in two ways, even though there's more than two. But on the one hand, you're kind of looking at what social control mechanisms or what things are allowed by the government to exclude people through the legal process, and that's something that the government holds on to as a right. On the other hand, you will see people saying, no, that's an unlawful abuse of power, both historically and today, and so I want to practice my rights. And so this is the tension that we were talking about between social control and individual rights. Lawyers and legal scholars and judges, they recognize that there's not one single answer, and this is very different than what you see on TV or what you might have thought when you came into this class. You're looking for the right answer, and then you just apply it. That's not how the legal system works. And so this is largely because of this thing called judicial precedent, which we'll talk about a little bit later in a different slide. And this is a way of using legal authority in order to argue a position, right? But try to remember that that's also based on that normative universe the person has. So their individual way of interpreting a text is based on their experience, their group, right? How they see the world, and that's how they're going to just develop their precedents. And so you're going to have multiple precedents that are going to argue with each other. And you saw that within the concept of sovereignty and who should make the final decision. And you all had different ideas on how that should even go about. And we used the example of in class, who should make the final decision as to your grade. So the malleability of law is this concept where basically what we're talking about is what I just said in number 1 through 5, right? And so because there's so much flexibility, and that's what we mean by the word malleability, this idea that law is not one single thing, but rather is this kind of tension that goes back and forth between social control and rights, challenges two of your previous beliefs, right? One, that you wanted to believe in a central authority. You wanted to believe that there's one group of people out there that are looking out for everybody and they're going to do the right thing. And that's, of course, not true. And the second thing is that many of you might have saw the law as a tool for social control is limited, right? You should be seeing this as that some of you say you want the law to be a rule of which there are consequences. However, there's lots of situations in which there aren't any consequences. The person gets away with something, especially what you call white-collar crime or the wealthy. In other situations, the crime is never reported. And so, law was not really useful at all there. But the final issue to think about is when that tool is abused for social control and it offends a group's consciousness, a group of people, especially those who have been unequal, they're going to resist. And at that point, law is no longer, right, actually having any consequences. It's actually producing unintended consequences. So there's dramatic consequences that follow from the idea of legal interpretation, and there's nothing you can do about it. There's no way you can have just one interpretation. We call that dictatorship or authoritarianism, right? And I don't think that's what you want. But even in those situations, as you look at dictatorships, they even have their own problems. And so there's no way to solve this particular problem, right? Every concept is going to be interpreted differently. However, through education, people can start to come to a common agreement, especially when you start looking at the systems that are producing the problem as opposed to the actual individuals. However, if you don't do this, then you're going to leave behind victims who are then going to, be more disorganized, and then you're going to have what we call social practices of violence, or where it appears that we're doing this intentionally as a system. I think, I don't think you can argue that, that the founders were so ingenious that they were going to know that 250 years from now they were going to be able to have a conspiracy to hold people down. I don't think you can say that. I mean, it could be possible, but that's just really hard to even measure, right? However, you can say that at this point we're all complicit, right? We're all involved in this. So if this 250-plus-year-old system is harming certain groups of people over and over again, which we showed you, Black and Latinos in particular, as well as poor people and people who have different gender and sexual identities, and we don't do anything about it, in other words, if we don't change the system, then we are practicing violence against those groups. So a lot of people then turn to rights, and they say, I want to know my rights, and I'm going to use my rights, and that's good, right? It leads to an awareness of injustice, but it does reveal that without an implementation of rights in practice, unless you're actually getting those rights, then you're left vulnerable, and you're not really actually getting anything from it except for more abuse. And so what we've been trying to do in this reader, my co-author and I, have been able to help you reframe how you approach the study of constitutions, and hopefully to forget about the concept of landmark cases, because it's a really stupid tagline in my particular opinion that probably sells textbooks but doesn't really teach you anything, and to start to think more about the social context of cases in general, right, whether they're called landmarks or not. So what we've tried to do is help you start to see structural injustice, look at controversies that repeat over time to kind of debunk that myth that things are getting better over time, but in fact, right, each generation has to start all over again. And so some generations do make more progress than previous generations, but other generations also destroy the progress of the previous generation. So you want to think about it that way instead of a march towards everything getting better. And then you want to start to think about how do groups mobilize as they start to become aware of the limitations of rights, and how do they resist the domination, and then start to construct new realities. And there's a reading on that in Unit 2 that kind of talks about how you can start to think about that. And I think a lot of the readings in Unit 3 we provided so that you get a way of seeing this throughout the cases. Now, we want to go back for a second to the formalist approach to rights because it's so common, right? Remember I said that the education system of teaching about law and criminal justice is also biased. And they tend to focus on the formalist approach, which you'll remember is saying, well, let's just look at the words, and we say, well, this is what everybody's going to get. And if it doesn't get it, then we'll try to figure out what's going on there, and it must be an individual situation. Well, if that were true, then here's how the 14th Amendment and the 5th Amendment would work for what we call due process. There's procedural process, which is the easiest really one to understand because it's like, the government didn't do something it was supposed to do. So for example, right, they didn't provide a lawyer or they didn't provide, a lot of you are focused on the Miranda warnings, and so the police didn't provide a Miranda warning, even though that's not always required. In fact, it's usually not. But it is a way of saying, well, the process was wrong, and so therefore my liberty or my freedom was taken away from me, and I want to exercise my rights. On the other hand, right, there's this thing called substantive due process, which is there are some things like life, liberty, and property that it doesn't really matter what the process is in theory, right, according to the formalist approach, that those things can't be taken away from you. Those are your inalienable rights, as it says in the Declaration of Independence. So that's the way the system is supposed to work, right? And some of you hopefully are laughing and saying, well, that's silly, right? It doesn't actually work that way. And so, of course, right, rights really, right, we look at the case Trump versus Hawaii, where the Chief Justice Roberts said, well, look, we know that this is a huge violation of the 14th Amendment. We know that, this has happened before in both the Kiramatsu case, in Plessy versus Ferguson, in Scott versus Sanford, in all these cases, in the Chinese Exclusion Act cases. This has happened a lot. But in this case, we're gonna side with the government and say, no, they didn't violate the 14th Amendment, or even probably better to say is, yes, they violated the 14th Amendment. However, we say because we're only going to apply the first level of analysis, which is, this is where your brain might start to hurt a little bit. You want to think of like stairs, right? So if we apply stair 1 analysis, then all the government has to show is a rational basis, meaning that they just have to have a legitimate claim, and that legitimate claim is not for us, the court, to question. It's just to say, is it possible? And so because the Trump administration said it is possible that during the pandemic, the people coming from the states that were banned, that were large Muslim or majority Muslim populations, because they could be a threat to national security, therefore it's okay. And so that's also the correct answer on the quiz, right? So under this rational basis review, the Supreme Court said they don't have to show that they're actually a threat, they just have to show that it's possible. And so we're going to say it's okay, it's constitutional, even though it violates the 5th and 14th Amendments. Now, on the other hand, if they had decided to go the next step, they wanted to go up the steps and go to intermediate scrutiny, the Trump administration would have to show exactly how those traveling from banned countries pose an actual threat. Like, for example, are they in some kind of CIA database? Have they been, accused or convicted of a crime in their home country? And then, they'd have to show what's the linkage, right? How do you know they're going to do it again? Was it a crime they committed when they were 12 and now they're 75? And what's the justification, right? They would have to show that something's actually related to what they're saying. And then under the third step, if you go up all the way, there's 3 steps, to strict scrutiny, they would have to show there's no other way, like, just screening people. So when they get to the what we presently do with pretty much everyone, right, is you go to customs and enforcement and you hand over your passport and they check the database and they see, whether you're in the database. They could even track people if they wanted. And so under that case, both under the second step and the third step, this would have been unconstitutional. And they would have said that the Trump administration violated the Constitution. But because they did the first step analysis, then it was found to be okay. It was constitutional to ban Muslims from the United States, and continues to be today. So what explains this gap? Well, remember the concept of polyvocality, right? People have different ways of defining fairness, law, constitutionality, right? And, not just people, but judges. And so we want to see how this actually applies, and we want to see what's going on here in the tension between rights and social control. It's pretty obvious they're tilting towards social control. So you want to go back to one of the early readings, and we already saw this with the meaning of sovereignty. So just like national security or the Due Process Clause of the 14th Amendment, judges have different opinions on what they think that means. And because there isn't one definition to rule them all, then this is what we're dealing with. And so different judicial interpretations of those concepts are going to create different precedents. And so you're going to have lots of choices when you're trying to make an argument within the legal system. They're not unlimited choices, right? You have to actually find the ones that have been said by judges in the past, but there are choices. And so this is what, again, we mean by malleability. They're going to be arguing using these choices. So the other issue here is that the different interpretations lead to different consequences. So different interpretations based on legal reasoning mean that Muslims are now not able to reunite with their family. If you could also Google right now who the United States government is giving travel visas to, they tend to come from light-skinned European countries, and they tend to be not allowing travel visas largely from South American countries and East Asian countries under the same logic, saying that, well, there could be a potential threat. Not that there actually is, but that there could be. And so that court ruling will apply to more than just Muslims. So remember that social theorist Hannah Arendt said, the problem with human rights is that you want them right at the time that they're being taken away from you. And at that time you're left as if you were naked, right? You're a human, but you don't have any rights. And so that's the problem with the language of rights. Now, she explains that this is, or she sees this developing after World War II, which is largely how most of the countries in the world are viewing rights and how they're seeing the legal structures, as part of territorial sovereignty. So in other words, you can only really act out your rights within the territory of the country that you're claiming them, and then you have to be recognized not just as a citizen or a subject of that territory, you have to be seen as deserving, as in you're good, you deserve to have this right. And so again, if it's an unequal social relations situation, then people who are being stereotyped or labeled as inferior or less than or other are not going to be seen as deserving those rights. And you can see this in the rhetoric and politics in the media. So the other issue here is that you want to think, okay, this is not just individuals doing this, right? This is the Constitution. Not everyone was recognized as having the right to have rights. In fact, it was only white landowning, property owning, slave holding males, or a few exceptions they created, merchants, farmers, things that they thought were relevant and useful to that society. Those were the ones who deserved to have rights. And so there's a whole groups of people, the majority population, was not seen as deserving to have rights. This is the design of the system. And one of the ways it maintains this contradiction, this paradox, is that it was designed in order to make sure that we don't have equal access to property. It's the one thing that separates us from other social contract countries, is that property is not a right that you have to be equal to. And so they promise the ability to acquire property, but they also promise the ability to make sure you maintain unequal property. In other words, they have guaranteed in the Constitution that the rich gets to stay rich and that the poor must stay poor in relative to the rich. Now again, this is not necessarily has to happen, but this is the design of the system. And so if you go to the legal system or the criminal justice system, policing, etc., this is the system they're defending. This is the system they're trying to close cases and protect. So unequal property is the contradiction in the system. So who says there has to be a balance? Many of you said, well, what's the balance here? How come they're not balancing? Well, who said there has to be, right? Isn't this your bias? Isn't this your interpretation of what you think fairness is? And so you should be able to see what the others are. I'm not saying one is right or wrong, but what I'm saying is that that's clearly not the way that the Supreme Court sees it. It's clearly not the way that the Department of Justice sees it. It's clearly not the way that police see it, right? So the actual people within the criminal justice and legal systems clearly have a bias towards social control. And so that's, of course, right? The police, judges, politicians, they're political human beings, just like everybody else. And they live in the same unequal social relations reality that we do. And so they're going to have implicit and explicit bias throughout the system. So you need to understand the majority of our institutions, education, banking, housing, healthcare, right, and a majority of voting citizens, want the balance tilted towards social control. They've made this clear over and over and over again for at least the last 50 years. So what about the minority? How do they protect themselves? How do they participate? How do they even get equal social relations? Well, I think my argument, and based on the research and my experience working with these groups, is you first have to see there's a huge gap between most people's expectations of what they think rights, justice, and freedom and fairness are, between what the actual system does. Once you start doing that, it becomes a little bit easier to see what tactics you'd use to resist and how you'd organize to try to get equitable justice. So the first step I introduced you in that week was to have you just identify the 4 paradoxes and write about one of them. And I think most of you did a good job. A few of you very obviously went to the internet and got a very wrong answer, but most of you were able to use the right answers here, and even those who got the wrong answer, here are the right answers. Although you should also read your fellow students' answers, is because many of them have really great answers. So what is this reading? Well, it was from a mentor of mine, a professor that I studied under, Michael McCann, who at one time was the president of this organization called the Law and Society Association. There's also the Academy of Criminal Justices, Sciences, right? There's lots of these professional organizations where practitioners and scholars like myself, we show up, we talk to each other, we write articles, and we try to figure out how to teach these issues, as well as what are some of the ways that we can solve some of the problems. So one of the things that he talked about at this organization was this concept of a paradox within rights, right? And so a paradox is a contradiction that seems like it's common sense, right? It seems like it should be able to resolve, but on the other hand is true, right? It's something that seems to be impossible to resolve, or at least very difficult. And so this is what we want to identify. So the first paradox was what actual claims count, right? And so rights constructions ensure order, less because they dupe or brainwash ordinary people, although in some cases I'm finding that they do, right? They do brainwash people in the way that we think about rights, but that's not the only thing they do. But it's because they're actually linked, they're harnessed to group power. So if institutional arrangements and the state system, right, government and criminal justice and legal systems are unequal, then rights are also going to be unequally applied because they're the ones who apply the rights. And so this means that it's difficult or costly for anyone who's trying to challenge that system, literally and metaphorically. Like literally it's going to cost you a lot of money and your life may be in danger or your person may be in danger. But it's also metaphorically. It's a difficult mental challenge. You're going to have to go through a lot of suffering and psychological turmoil just to get there. And so this is largely why it takes an army or it takes a village to kind of accomplish these tasks. Disadvantaged groups have to be able to organize in order to make a change. The second contradiction is the promise of individual freedom. It sounds nice, it's a lovely idea, but it's a substantial burden to have anybody actually have something like social responsibility defined, because it's kind of like this constant weight that what's good for the social order might not be good for the individual, and so therefore the individual wins. It's a very strange way of thinking about things, but again, it's embedded into the United States Constitution. So while rights may operate as a force of emancipation, there's really no way to be free without them. At least in our studies of history, for example, like the civil rights movement or the ability for women to vote, on the other hand, they also can become like a way of talking, which we call a regulatory discourse, that makes it difficult, obstructs, or even like changes people's attitudes when they have something more radical, like they want to change the economic system, or they want equal housing, or some of these things that would actually make them equal or free. It reduces their concepts to say, well, I have to file some paperwork in the courts first, and we'll see whether the courts think I am entitled and deserve a house or a loan, or not to be discriminated against in the education environment. And so this ends out to be kind of an empty promise if the court comes back and says, no, you actually don't have an individual right. The other thing is who can claim rights, and this has kind of been over and over again. I've talked about it a lot, right? But he references Dr. Martin Luther King Jr., which you read. We hold these truths to be self-evident, that all men are endowed by the Creator with inalienable rights. That's a beautiful creed. He's almost saying it sarcastically, and yes, it's great. It's an awesome idea as aspirational. We should definitely want those things, although some people don't want that, and it seems like more and more people don't. What he was trying to say was that it challenges the idea that how do you have that concept at the same time have segregation in schools and housing and economics, right? How do you have these divisions and discrimination? And how do you have so much poverty while you have so much richness among the other group? And so he says very clearly America has never lived up to this idea. So the rights are useful in that they get us to see what we want there to be, but that's not enough, right? We have to measure that against how it's actually happening. And if it's not working, we have to rethink our approach. And then finally, as a potential resource, it is useful. It can be useful as people start to organize because they recognize that they had a right that got taken away from them, and this isn't right. And so they start to organize, and they start to then see this, what we call the politics of rights, as they start to not get rid of those rights, but basically start to see, okay, this is something I have, and then I need to use it in order to assert my agency, in order to make a change and say, what, I have dignity and respect. So we want to think about this again within the context of the course and learning outcomes, right? And so you've been trying to think about how do you explain these differences within legal institutions from a philosophical point of view. And what we mean by that is just from basic life experience and the big questions that we tend to ask. How do you start to no longer think about the universal moral idea that law is just one thing, and you start to think about how law can be at least three things. It can be something that I feel like I'm using, like a game. I'm with the law. I'm trying to use it to organize and to protest. I can feel like I'm up against it. It's coming after me. It's discriminating. It's segregating, right? It's doing these things that are harming me. Or before the law, where I feel like there's not much I can do because it feels like an authority figure. You'll then be able to describe how this is useful, right? Once you understand this, how can it be useful to start to make social change? Again, to help people think about it, give them a language, and help them recognize when they're being discriminated against. And then you'll start to identify how groups use this to mobilize against injustice in the future. You did see a little bit that with Patricia Hill Collins as she writes about the power of writing. I think it's evident in the Martin Luther King Jr. Writing, right? He's writing to show and persuade other people. But there are other examples in there that show you how people organize against injustice using the concept and language of rights. And then you'll be able to describe how these life experiences and these different interpretations, or in short, difference, how difference helps people have different identities and then communicate what those identities are as an important way to interpret the world and what's going on in the legal system. And so again, you did that through looking at racial discrimination cases first, and next you're going to look at issues that have to do with sexual identity and gender, and then finally you look at more economic and administrative issues. And then the question you were asked was, for the discussion board, was using language from the judges, compare and contrast two of the racial discrimination cases. I saw most of you did a pretty good job of that. What some of you failed to do was, what did you learn about historical discrimination and how did you explain it, right? So then we go to the rubric. And so answering that question, as well as who benefits from the discrimination, right? A great answer, a 5-point answer would be, you'd be evaluating how judicial decisions affect the social relations. So judge said this is what happened. But you'd also be able to show how the legal rules the judge is using actually work against social change. So it's not just that one judge is saying something bad about Scott versus Sanford, it's the whole system of legal rules is actually making it impossible for Scott to be recognized as a person who deserves rights. You'll also be able to better evaluate how historical injustices like racial discrimination and forcibly enslaving Africans persist throughout the system. So you'll start to see that this is the same issue that comes up again in Brown versus Board of Education, going to that normative universe of who deserves to have an equal education, who deserves to be integrated with rich white kids. And then finally, you'd be able to describe the tension between law of social control and law of rights, and really explicitly say, it's whites and elites and powerful people and wealthy people who are using the legal system for social control against quote-unquote others, anyone they don't think deserves to be a part of the equality of the system, in order to control those people, and so they're willing to violate their rights. And so you want to be able to use that kind of language, and some of you did a pretty good job of that, and then you want to get better at that for the remainder of the work. So how are we actually doing? So I think some of the answers weren't great, but most of you did see that there's a pattern. And so it's not about individuals. So that's a big improvement from week 1. So that's great. That's what I like to see, and many of you are doing that very quickly. You're starting to see it's a design system. And so some of you, I don't want to go through all these answers, but I've given them here so you can pause and you can read through them if you want, so you can kind of see them together. But I want you to be able to maybe see the difference between those that are explicitly identifying white, wealthy, powerful people who are benefiting from the system. I would say also middle to upper middle class white people are benefiting from the system, and then middle class people, regardless of race and gender, tend to benefit from the system. And so you want to see who this is hurting, right? It definitely hurts black people in particular because it's targeting them, as you saw through the legal cases, but also you saw the Latinx population, especially young men. And then also it affects poor people and people who have different identities than the norm. And so you want to be able to say that explicitly rather than saying this is unfortunate or it's not a good thing, or right. Those are kind of hinting that it's accidental and it's not a system that is controlled and designed by people to maintain their power. And so you want to make sure you're not falling into that kind of race neutral or colorblind trap where you're pretending not to see any of the things that you just studied. And in fact, I really like this answer here, is that the student was kind of writing in response that the judge violated the 14th Amendment in order to keep the status quo. And that's very important to see, that judges are not necessarily going to do exactly what you want them to do or what you think they should do, right? They're often going to defend the status quo using the court system in the legal language of the past. As you saw in the abortion case, the Dobbs, right? They did not use the cases from 1950 to 2023. They went back in time and used older cases and used even dissents in cases where people disagreed. So I just want you to keep in mind, right, that the school system was not and is not designed for most of the students we now teach. In the previous slide, you saw a headline saying New York City's schools are actually more segregated than they were during the Brown versus Board of Education case. And so, just because the Supreme Court said schools should not be segregated, that didn't mean that they were not. They are more segregated now. I know it's very confusing because students say, well, it's so diverse, right? But think about who's not there, right? It's the upper middle class and wealthy students who are not there, and there's a huge number of especially wealthy white kids that aren't there. And so you're not getting the same advantages, you're not getting the same benefits, you're not getting the same access, you're not getting the same internships, and in some cases you're not even getting the same learning materials, right? Because there's an emphasis to give you free materials, and sometimes what you pay for is what you get, right? And so there's a lot of different ways we have to try to attack the system, but you have to understand the school system was not and is not designed for most of the students we now teach. Now close to 50% of students now go to community college in the United States, and that's a huge number. And they're most first in the family working class students, and that's not what the system was designed for. So it's going through a radical change and resistance, right? Some people don't want to make change. So the materials have to change, must change too. They have to reflect the lived experience of lots of different people, particularly people who've gone through actual injustice, and then also to provide space for students to discuss what can be done. I'm trying to do that through the open-ended prompts in the quizzes and the exams, but also to give you space in the discussion board to now that you've seen the problems, to start talking with one another and thinking from your experience, what do you think would be good to do structurally, right? So what can we do within education, what can we do within criminal justice, what we can do in the legal system to make changes. One idea that's floating out there is term limits for judges, right? So you get different types of judges and more judges. Another issue is ending the legacy admissions to the Ivy League schools. The other issue is giving more money to community colleges so that you've got so instead of getting free textbooks, that you get textbook vouchers, right? So that you get quality textbooks, but you don't have to pay for them because the federal government is paying for it. So different ideas like that, as opposed to just let's all hold hands and hope everything gets better. And then finally, you want to identify the key terms and concepts in the reader, because you want to start using these in the final 2 weeks of this class, and definitely on the final exam. So you want to be thinking about advocacy, agency, and your identity, and thinking about how that now applies to the civic education gap, that now you know who you are within the concept of the class, right? That you understand where you fit within the structural inequality of the legal and criminal justice systems. Start to think about how you could navigate those unequal structures and how you defend yourself in the future, and then how you might be able to act on behalf of yourself and other people to make changes. This would go a huge way of closing that gap in civic education. You want to contrast this with the formalist idea that we just have to look at the law and in a textbook and say, well, that's good enough, right? That everybody's got an equal opportunity to get their rights recognized. However, you should know now that you see that's not real, that doesn't happen in real life. You want to think about judicial discretion and judicial precedent and how they go together, and you want to think about especially what you saw with sovereignty and how that kind of applies through time. This will help you better understand the polyvocality of legality, or multiple positions of thinking about stories about law, and this will also challenge your ideas about the myth of rights, right? That just knowing your rights is enough to actually get protection. You'll also see the malleability of law, or the changeability, the bendability of law that depends on those judicial precedents, and those are different. And so you've got choices to choose from when you're making your arguments, but they're limited to those previous cases and those precedents. And then finally, you want to kind of start to think about how your standpoint, in other words, how your particular identity, so what your race, class, and gender, economic status, all these kind of things that might inform who you are and how you're recognized by the system. For example, what you fill out on the census or what you put on a job application. How does that change what your chances are for equality and for success? And this is now kind of getting to the threshold concept of saying that not everybody is equal, and the legal system and the criminal justice systems are not fair, and they will be biased against those who are less than or seen as unable to compete within that kind of upper class way of thinking about the world. And so this would be transformative learning as you start to change the way you think and start to say, okay, this is what I need to do in order to make a change in the system, as opposed to trying to say, well, this is what I need to do to change myself, right? Which would be very damaging and not very helpful in the long run, right? You need to be the best you can be, but you don't have to change for anybody else. The system needs to change, including the education system. So these are the things that we're trying to get you to think about, and we'd love now in the final weeks to hear more about your ideas. So thank you for your hard work, and keep it up.